Okay, so this week I want to try to finish the section on contract law, that's being chapter 10 and 12 and 13. And then next week I'm going to be going back on to corporate law, and we're going to have the midterm test. I'll be emailing you about that and give you all sorts of notice about that and how I'll be doing it. So, and then we'll move on to contract law or corporate law. Okay, chapter 10, writing and interpretation. I'm only going to be dealing with the part of chapter 10 that deals with contracts that have to be in writing to be enforceable. And particularly, I'm going to be talking about this legislation called the Statute of Frauds. But as page 208 of the text points out, you have to understand that to form a contract, it does not have to be in writing. The formation of it doesn't require it to be in writing, although we have a lot of contracts nowadays that are in writing. To form a contract, you don't have to have it in writing. It can be oral in nature or be part oral. It can be part oral and part written or all written. Now, as page 208 points out, and I'd recommend that you read page 208 under the heading Benefits of a Written Record, it's always better to have a contract in writing to avoid misinterpretation of it and so on and so forth. So that's explained there. But you have to understand that a contract need not be in writing to be formed. But now there are some contracts that must be reduced to writing to be enforceable. It doesn't mean that they don't exist, but to be enforceable, they have to be in writing. This is provided for by a statute that's very old called the Statute of Frauds. That's pointed out at page 209. And it says there in the second paragraph under that the Statute of Frauds makes certain types of contracts unenforceable unless they are in writing. An otherwise valid oral contract that falls within the statute is unenforceable. That is, neither party can sue on it. This allows a party to avoid performing a contract solely because it's oral in nature. The contract might be perfectly valid in every other respect, and so on. So the contract exists, but it's unenforceable. So what type of contracts does this Statute of Frauds cover? Now, this Statute of Frauds is almost 400 years old. I don't want to get into the history of it. You can do that if you wish, but for our purposes, that's not necessary. But as page 209 points out, under types of contracts covered by the Statute of Frauds, we have three that I want to deal with. That is number 2, or a promise to answer for the debt, default, or miscarriage of another, or called a guarantee, or a contract concerning or dealing with an interest in land, and an agreement not to be performed from within 1 year of its making. Okay, so again, just to summarize then, we have contracts that are guarantees, have to be in writing to be enforceable, or contracts concerning an interest in land, or an agreement not to be performed with 1 year of its making. There's a couple other ones that it applies to, but for our purposes, that's not important. Let's deal with a guarantee first. A guarantee is used in business in many ways, especially when someone's getting a loan from a bank. So if you're ever a loans officer in a bank, you have to be familiar with guarantees. What it is that you make a loan to somebody, and you might say, on top of the loan contract that I'm making with you, I want someone else to guarantee that you pay the loan. This is called a guarantor. So you may get your mother or your father or your brother or your sister or your spouse to guarantee the loan to you. As the book points out, a guarantee is a promise to answer for the debt, default, or miscarriage of another. It is a conditional promise to pay only if the debtor defaults. If he does not pay you, I will. Only after the debtor has defaulted may the creditor claim payment of the guarantor. So, by the guarantor. So, again, we have a loan situation at a bank where the bank lends someone some money and they demand that in addition to his promise to pay them back, that he get another person to guarantee the loan so that if he doesn't pay, the bank can sue them. Okay? That, if you have a contract of guarantee like that where someone says, lend so-and-so the money and I'll guarantee it, that must be in writing to be enforceable against the guarantor. If it's not in writing, then the bank cannot enforce that guarantee against the guarantor. That is explained in page 210. But the big one for our purposes is contracts concerning an interest in land. This is set out on at the bottom of page 210. And this is the where the we'll deal with in real estate, the real estate section more, but this is where the deed of land originates and whatever. Any contract that concerns the sale or mortgaging of land must be in writing. So if I'm selling some land, I have to put that in writing. And this is the origin of something called the deed of the transfer of land. At the bottom of page 210, it says this: land. Requiring that contracts concerning interest in land be in writing is necessary to protect the public record of land ownership. The special qualities of land in particular is of virtual indestructibility and permanence make the ability to ascertain the various outstanding interests and claims against land important. It is essential to have verified written records of transactions affecting interest in land, and these records must be available over years. Therefore, we have systems of public records where interested parties can find out who owns land. So, but there's always exceptions in law, like I've explained to you before. There's this doctrine of what we call part performance at page 211. This says that even if you have a contract concerning an interest in land that's not in writing, let's say I'm selling you my house for $250,000 and we shake on it and orally agree to it, that's unenforceable against me. So if I break my promise, you can't sue me and force me to give you the property if you pay me the $250,000. But if we've completed something called part performance, then you can sue me even though the contract is not in writing, is totally oral in nature. This is explained at page 211 under the doctrine of part performance, which says this: to prevent fraud, the courts developed an exception that allows some oral contracts to be performed despite the statute of frauds, even though they are oral in nature. It is called the doctrine of part performance. If the plaintiff can show that performance of the contract has begun and he has relied on his existence, the court would accept that performance as evidence that the contract exists without it being in writing. But it must be, as the doctrine explains on page 211, the contract must be one concerning land, and the acts of performance must be quite clearly relate to the existence of a contract. And this is set out in case 10.2, acts of part performance. I'm not going to read that back to you, but you can see that in that case, the building and maintaining of gates and ramps were clear, unequivocal acts of part performance, and then that contract was held to be in existence and to be enforced against the government of Nova Scotia.